Everyone, good evening, my dear friends, all my dear law students, law graduates of different law schools across the country. I am very happy to welcome all of you today. I am Nachiketa Mittal, a law teacher, and we are today having the inauguration program of Judicial Preparation and Advisory Center, which is a unit of HiEdu Learning and Mentor Solutions Private Limited. I am here for the inauguration where I take the privilege of welcoming our distinguished guests for the day. So we have with us Shri P.K. Malhotra, who has been a former law secretary in the Department of Law and Justice, Government of India. Mr. Malhotra has been supporting even the virtual law school, which was initiated and started by me a few months ago. Abundantly. Mr. Malhotra is a very leading person in the field of law with diverse experience and has served for more than 25 years as an officer of Indian Legal Service and has also reached to the apex level of Union Law Secretary. So Mr. Malhotra has been responsible for processing, finalizing some of the very significant legislations of the country, my dear friends, including Criminal Law Amendment Act of 2013, which we all study as part of our law curriculum, then constitutional amendments relating to National Judicial Appointment Commission, Companies Act 2013, Representation of People's Amendment Bill, Commercial Courts Act 2015, which was again one of the very important legislations that we saw in recent years, including Arbitration and Conciliation Amendment Act 2015, Insolvency and Bankruptcy Code 2016, so on and so forth. So there have been so many, kinds of these legislations for which Mr. Malhotra has been, part of that process of developing them. And, we all as the law teachers and lawyers and law students have been benefiting from several of them. So I am very happy and it's my privilege to welcome you, sir. Thank you so much for agreeing to join us today, this evening. Then, my dear friends, I am also honored and happy to welcome Mr. Amit Vashist, who is a regional PF commissioner with the Government of India, is based in Delhi. Mr. Vashist has also been leading the academic, department academic side of the Ministry of Labor and Employment of Government of India, which is located in Janakpur in New Delhi, which trains the Provident Fund commissioners. And has been posted in Delhi since a long time. I had a good fortune of also delivering few lectures in the PF Commissioners Academy when Mr. Vashist was the director there. And I'm very happy to share with all of you that Mr. Amit Vashist has been also teaching in the virtual law school that we started a few months ago on the subjects of cyber crimes and cyber security. So welcome you, sir. Thank you so much for agreeing, on this Sunday evening for the launch of the another program of Judicial Preparation and Advisory Center. Then, my dear friends, I am also very happy to welcome Mr. Suman Jyoti Khaitan, who is the founder and managing partner of Suman Khaitan and Company. And sir has been practicing lawyer since 1985. And Suman Jyoti Khaitan is a full-service law firm having associates in major important cities in India. And Mr. Khaitan has been, practicing in diverse areas of arbitration law, aviation law, bankruptcy and insolvency, business restructuring, competition law. And Mr. Khaitan is also a member of leading chambers of commerce, including CII, FICCI, SHM, and ICC India. But to also tell you, there's one very interesting aspect that may be necessary for my law students to note here, that that you may wonder that when I was a law student in 2003, I interned in Suman Jyoti Khaitan and Company under Mr. Khaitan's supervision. So what I want to also convey to a lot of my law student friends here is that when you are in your law school years, these are the formative years. Do not take, I'm just taking one cue out of my own experience here. Do not take even a small kind of an engagement of your internship lightly. It's about the impression that you're going to leave behind, which you may probably be able to harness after several years out of your diligence and work with any law firm. So do not take any assignment which is given to you lightly. You never know how people may be observing you and how people may actually try to find a potential in you, and at the same time you may benefit by virtue of being accredited or acknowledged years after. So I am very grateful to even Mr. Khaitan, that after my several years of interning in Suman Jyoti Khaitan and Company, and to tell you that was the time when I was not in one of the leading NLUs. I was from one of the very regular law colleges of the country, but this was one of my very premier kind of internships which I got that time. So I was very happy, that time. For the first time I went to Delhi and interned all alone. Right. So thank you, sir. I know, even going back to those days, and thank you for joining us today. So, my dear friends, now before we begin with our speakers sharing their thoughts on how the judicial preparation should look like and what we are trying to achieve here, I would want to brief everybody about two kind of things. One is definitely the virtual law school, which has been the foundation of lot of work that I've been doing since past few months, having taken a break from the active institutional law teaching from the National Law University, Orissa, and after that as the Dean of the United World School of Law in Gujarat. So now, since I've taken a break from the active university law teaching, I started up initially with the virtual law school during the national lockdown in the month of April. So that was the time when we were just grappling with the entire issue of legal education going online, and in every sense, every other kind of discipline. So I thought of, reaching out to a lot of law students who probably would be left behind in this entire competition and who might not have been able to go to the very reputed premier law universities or state private universities and law schools, and may not be touched by these benefits of the online law classes. So I tried to speak out and reach out to a lot of my friends, and a lot of people supported. And in particular, I will always remain thankful and grateful to even Mr. Malhotra, who is part of the inauguration program of the virtual law school. Then Honorable Mr. Justice A.K. Sikri, the former judge of Supreme Court. Honorable Mr. Justice Kurian Joseph, again former judge of Supreme Court. Mr. Siddharth Luthra, who is a senior lawyer. Also Mr. Rajiv Luthra, the founder and managing partner of Luthra and Luthra. Then we also had along with us, the vice chancellors like Professor Shanta Kumar of Gujarat National University, then Professor Yogesh Pratap Singh, who is registrar of NLU Orissa, Professor Manoj Kumar Sinha, who is director of Indian Law Institute, and several other lawyers and professor friends join in this kind of a movement to make it success. And that's how we have traveled quite a long way through, in that sense of rendering pro bono legal education to a lot of law students. And although it was a private initiative of law teachers, but we tried to, despite that, do whatever best we can, discharging our responsibility. So when we started from pro bono, later we shifted to what we called as a low bono. To make the institution sustain, we began charging only 750 rupees per lecture for full course. And even in that, sir, it will be a matter of interest for everyone, including our panelists here today, that despite being a private initiative of a law teacher, I, since April 2020, earlier this year, have been teaching every student who is especially able or belonging to economically weaker section completely free of cost. For all kinds of classes that I've been running, I'm not the state entity, I'm not even the private university or a registered college with BCI, but this has been my belief system, and that's what continues till date. Even any student, and I have some of the students who opted for as many as 12 to 13 courses, and I'm not charging a single paisa from them, provided they are able to furnish that EWS certificate or especially able, which we verify at our end, and after that we render all our services to them. So now, when all of this was going on, my dear friends, lot of students, law graduates, even my own students from different law schools approached me that why don't you start the judicial preparation center as well? That's going to benefit a lot of law graduates. The reason is that in these challenging times, although there are a lot of other judicial preparation centers, and institutes, and everyone is going online. But this has been the constant demand since last 3 to 4 months from our students, and I was thinking and contemplating on this issue since a long time. I consulted some of my lawyer friends, some of my professional law professor friends, and reached to the conclusion that probably the time is right. And what I found, sir, one of the very interesting issue in this way, but at the same time an issue which slightly disturbed me, that most of the judicial centers or institutions which are of private nature, which are preparing the aspirants to sit for the judicial service examinations, they all are doing a good job, but at the same time, their student or a candidate has to take up entire package of learning for 6 to 8 or 12 months of judicial preparation. It involves a heavy cost. Now, when it involves a heavy cost, I find that the students are often sort of in a situation that they cannot opt for one or the other courses, but they have to take a comprehensive package. Now, I thought about it very seriously, and being a law teacher and also having my own history of the virtual law school and my efforts which I've been putting in, I thought that definitely I can venture into this area and try to help our students prepare for it, which will probably be a new kind of a dimension. But in order to make it more promising, what I have done is that here at the Judicial Preparation Advisory Center, we are not forcing any student, any graduate who wants to sit for the judiciary advising, judicial service to take up the entire package of 6 months, 8 months, 12 months, or things like that. Rather, we have split those things into branches. For example, somebody in these COVID times, you all are undergoing a crisis of finances. Not all parents may be able to afford the fees after admitting their children in the law schools. So I thought that why to force somebody to take up the entire package? So I divided that into branches. That, for example, in somebody's law school, a law student may be having a fabulous faculty of procedural law, so that a student may not necessarily have to take up the procedural law learning for the judicial service examination. So that student or a candidate can only opt for probably the civil law or the criminal law or the core substantive laws, including constitution and administrative law and jurisprudence and so on and so forth. So we try to develop here, thinking through and talking to all of my professor friends, that can we give that kind of ease of learning rather than trying to create an environment where the judicial preparation appears to be slightly suffocating and quite tedious and very, I would say, disturbing after a few months, that you are stuck in one kind of approach. So that is what we are trying to bring on board. And another angle to it, my dear friends, is that the Judicial Preparation Advisory Center, through this, we are trying, to also rope in for few projects where our studies can also help in terms of supporting some kind of research centers, some law schools, to develop and also see that how we can meaningfully contribute through the research in terms of generally improvising, improving upon the lot of literature on the judicial side. In that regard, I and one of my colleagues, we have recently sent a paper and a chapter for a book which is coming out on judiciary, where we have argued on the gender diversity angle in the Supreme Court and the High Courts. So the idea behind this entire process is that not to only prepare the law graduates for the judicial service examination, but also some of them who may want to be a good researchers looking at the judicial studies altogether, they are also most welcome. So, and then moving forward, so we are, as all of you can probably now understand, it's law teachers driven process. It's not a process which we are driving as individuals merely on the commercial basis, but everyone who will be teaching will be well accomplished law teacher. Some of those have also been the aspirants of the judicial services earlier, have sat through the judicial service examinations and have also cleared them. But as the man proposes and God disposes, so sometimes it does happen, vice versa also. and there some of our very well accomplished teachers could not land up in the judicial services, but they took up full-time law teaching. Nevertheless, their passion for the judicial services and coaching the young graduates did not die, did not fade away with time. And I was able to reach out to some of those friends and bring them together under the same sort of thinking process. And here we are offering you the Judicial Preparation and Advisory Center. So this was all about, that I wanted to mention to everyone, that this has been our approach, which is going to be about the ease of preparation in this regard. Now, on that note, I now would request our speakers for today to share their insights. And first of all, if I could request Mr. Amit Vashist to share his diverse views, because I remember since 2014 I have been discussing issues of these kinds with Mr. Vashist. At one point in time, to be honest to you, I was almost convinced that I should have left teaching and sitting for the competitive exams. So Mr. Vashist has been quite instrumental in motivating me for that, but that didn't take through in its entirety. So Amit sir, I request you to share your thoughts.
Thank you, Nachiketa. Good evening, everyone. Good evening, PK Malhotra sir, Mr. Suman, Jyoti, Khaitan, and everyone present here. First of all, let me congratulate Dr. Nachiketa for this monumental task of taking up Judicial Preparation and Advisory Center. As he has very rightly stated, that this idea of taking this initiative was being pondered over for probably last 6 months, and we had some discussion over this. In the end, in the beginning, he had some reservations about it, whether to go about advisory and coaching center or not. And maybe he had his own doubts about the academic merit of undertaking this exercise. But after a lot of discussions, I'm happy that this has now been finalized, and now it is taking shape from today. In fact, this COVID time, for whatever difficulty it has posed before us, there's some, as it is said, that every dark cloud has a silver lining. And the silver lining of this COVID time has been that it has taught us a number of skills. And this conducting webinars, or maybe this technological upgrade that all of us have acquired in this time, is probably one such advantage of this time. And one distinct learning I had from this time is that physical presence is completely irrelevant so far as academic exercises are concerned. So right now, I think many of us are from Delhi. Nachiketa is conducting this program from Ahmedabad. Some of the students may be from different parts of the country. Ordinarily, to conduct a program of this nature would have required tremendous resources. It would have required a lot of time for us to travel and be together at one place. And although all this technology was already there, it was only to be explored and utilized that this difficult time has made up to do all this. So one advantage I think of this technology is that the students who would be interested in taking up these classes would not have, for the quality of education, there would not be any constraint of one, time, and two, physical distances. Now, my association with Dr. Nachiketa has been long. In fact, as he has stated, we had organized some lectures together in the National Academy where I used to teach. In fact, in the Indian Law Institute, we have also taught together for the students of postgraduate diploma and LLM classes at the Indian Law Institute. And my assessment is that his taking up this exercise would be immensely helpful to the students. Firstly, because the color and contour of judicial services exams is now completely changing. 10 years back, while these examinations would probably rely upon the rote memory of the students taking up these exams, now the focus has probably shifted, and it is more on the conceptual clarity of the student. So more questions, particularly in the written exam, they would focus on the conceptual clarity a student has. And now this takes us to this immensely unique part of this preparatory exercise, which is more about strategizing rather than the bulk of study material a student takes up for his preparation. And then there is also the importance of an able teacher who can guide a student through the process of this preparation. And I'm very happy that Dr. Nachiketa and his team would be taking up this additional enterprise, this additional work, which is in itself a very worthy initiative. And I'm absolutely hopeful and enthused that this would be of unique support to the students who will be taking up or preparing for these examinations. So my all good wishes to Dr. Nachiketa and his team, and also to all those students who will be taking up these preparatory and advisory services from this center. All the very best. Thank you.
Yeah, thank you so much, sir. Thank you for those words of encouragement. And definitely that's the idea, that it's not just about the traditional approach of preparation that we are looking at, but also to uniquely blend into that conceptual clarity and learning that could stay with the graduates who are aspiring for the judicial services for longer time. And in this process, I can also assure you that since I have several of my own students now who are serving as the sitting judicial magistrates and judges in different places across the country. So while I was, planning the entire Judicial Preparation Advisory Center, I reached out to also some of them to understand that, when they were preparing, so what were the challenges that they faced? How did they come up, and overcome those kinds of challenges? What has been, their journey throughout the process? What could be their thoughts, their suggestions, that what are the areas we can plug the gap through, which we can incorporate as part of the new initiative that we are now taking up here. So why? Because there's no point, I believe, reinventing the wheel and also traveling the same road that others have gone through, and they might have undergone certain challenges. So that's the process that I try to deliberate upon with some of my friends who have been in the judicial services. In fact, there are a couple of my roommates from the LLB times who are already in the judicial service, for last 10 years now. So they have undergone a journey, and they have also been coaching in that sense of mentoring their own, young friends to do a lot of things. So we are trying to look at all of those also. So thank you, sir. I do understand, and thank you for reposing faith that we can, live up to that kind of expectation. So may I now request, Mr. Suman Khaitan to share his views about, how we can probably also make it a little more robust as a program and try to distinguish in its sense of making judicial service preparation more comprehensive and incorporating several kinds of, new insights that sir can probably tell us to do.
Well, thank you, Dr. Nachiketa, and good evening to all of the friends present here. It's very nice of you to bring this together. And of course, I've known Mr. P.K. Malhotra even when he was a law secretary and even after his retirement. And his experience and his vision and wisdom would be very important for all of us. I also wish to just say my hi and hello to Mr. Amit Vashist, who's the Regional Provident Fund Commissioner. He himself would know how much money has been withdrawn from the Provident Fund accounts to understand the depth of the problems which India is facing at this moment. But sir, apart from that, it's very good, sir, that you are here, because even your administration and the officers can gain a lot by judicial training so that their decisions are not challenged too often in the courts. So as we know that in a huge population like us, it has really tested our judicial administration. And during this lockdown period, I've taken this opportunity to read a lot of books, including the Tagore Law lectures on the codification of laws from the British India Times, and also the speeches of Lord Macaulay and other people who, of course, British. Some people may not like that idea, but their views are still very relevant. While speaking on the concept of making laws and the understanding of the judges, one point which was mentioned by all these people who are, of course, lawyers, and some of them were also administrators with some experience in Britain, was that in legal system, you must always have clarity and certainty. The laws may even be wrong, but without certainty, you can never have justice. And the initial law commissioners of India, who were part of the first, second, and third law commissioner of India, had also clarified that the laws keep changing fast, and even at the pace of developments, 150 years ago, they recognized that commercial law is changing, globalization is a fact of life even 150 years ago, and they said in the law system, we must have a mechanics that the laws are revised periodically, every 3 years or 5 years. Unfortunately, these are all advice which we seem to have forgotten, and we have to remember again. So you will remember that during the British days, all the judges who were appointed from the magistrate level to the court level, they were not necessarily qualified as judges. Some of them were appointed by the East India Company, who were the officers of East India Company. Some of them were from the civil service. Some of them were from other services from UK. Some were practicing lawyers, and some actually were people who were transferred from the services of the company to the judiciary, and then back from the judiciary to the services of the company. Nonetheless, they did a great job, and some of the earlier Chief Justices, including Mr. Barnes Peacock, and some of the people who were the Chief Justices of Calcutta High Court, Bombay and Madras, they were also scholars. Sir William Jones was a great Sanskrit scholar, and he used to write books. He also wrote books. He translated the Indian scriptures into English, etc. So what follows, sir, is that for a judicial training, merely studying the syllabus in a law school has never been considered enough. If you take the old great judges of UK, whether it was Blackstone, whether it was Lord Coke, whether it was Halsbury, and later on whether it was Lord Denning, and even the great judges of America, whether it was Justice Holmes, Justice Marshall, or the recently deceased, a lady judge, I think Sarah, she just passed away recently due to cancer. Education is very important for a judge. You can read the Bare Act, you can go to a law school, but unless you understand human psychology, unless you understand the systems and the culture and the social aspirations of the people whose actions you are going to judge, you can never be a good and proper judge. Because ultimately, you're not just enforcing the letter of the law, you also have to render justice. Different people understand law and implement law differently, and you must understand the psychology to see the intent. And you must remember, in a country like India, with a vast number of people who are uneducated, they are not literate enough, they don't have the money to study and have a formal degree. To impute a knowledge of law to everybody is, of course, not only incorrect, but also unfair to them. Supreme Court of India was itself conscious of this, and they devised their own system called public interest litigation. A lot of the justice and the balance between the rigors of the law and the needs of justice was delivered by the courts, by inventing a new form which was not provided under the CPC or in the enacted law, namely the public interest litigation. So the law, sir, as we know, is very, very complicated. Whether it's the Code of Civil Procedure, whether it is the Criminal Procedure Code, or any other statute which has been formed with the best of intentions, because the law is to cater to a diverse multitude of circumstances, it is very difficult to make it simple. Leave alone Income Tax Act, leave alone GST, even the company law today is becoming very, very complicated. For everything, you need the permission, even to have a board meeting and to draft minutes and to complete the minutes. You require to follow a lot of procedures, which, in my view, is totally irrelevant. It would be very helpful if the judges understand this practical problem, which the litigants before them are going to face and are faced every day. In the lower judiciary, where your training school, people who will be trained, who will pass exam, will become magistrates. It will help them to learn from the perspective of the litigants, from the perspective of the complainant, from the perspective of the accused, how much difficulty and experience they have to face. So today, Mr. Malhotra will know better, even for a small offense of not filing your returns on time, you can be faced with prosecution. You can be summoned before the magistrate. You can go to jail. I'm not sure whether it is all that is necessary. Now the government has appointed a committee where Mr. T.K. Vishwanathan is also there, the colleague of Mr. Malhotra, to review all this law, whether so much penal action is at all required. So take a simple subject of 138. If it is check bouncing, in most jurisdictions, it will be held to be cheating. It will be like giving somebody counterfeit cash. But if you see the language of 138, it needs much to be desired. You just see the amount of judgments which has been delivered on a simple thing like a check bouncing. Most countries it will never happen. You have tens of thousands of judgments just because of 138. It is something which should never happen. If a magistrate gets proper training, which Dr. Nachiketa is about to start, and they also have some internship with either the counsel who go to court or with the law firms, they will also be exposed to the day-to-day requirement of a commercial person. You must understand, sir, that a person who comes before court, he is not trained in the law. He's just doing his business. He may be a shopkeeper. He may be a big business magnate. His job is not to study law or the court procedures from morning till night. Then how will he do his business? Now, if you see the Arbitration Act, it was supposed to be inexpensive and an alternative method. Mr. Malhotra knows, all of us knows, it is neither inexpensive, nor is it brief, and the whole thing, perhaps, the object and the purpose of the Arbitration Act, again, needs to be revisited. Even after the 1996 new Act, there have been thousands of cases at the High Court level, at the Supreme Court level. Sometimes even the court takes a conflicting view. Now, why is that Act so complicated? Why can't we make it smooth and simple? I would suggest that all this, if a judge or a magistrate, at whatever level he joins, if he has training which is between the law school and kind of your association, plus training from the practical point of view, he will be more sympathetic to the cause of the complainant. He will also understand some difficulty of the accused. Maybe the accused was not so wrong, and he will also know when to convict an accused and when to be more sympathetic with him and when to impose costs. Even a system, sir, of imposing costs needs a review. In arbitration, if you lose, the entire cost is imposed upon you, but not in judiciary, not in the civil court. Many times the courts are imposing imprisonment and then say, if you pay 10,000, 20,000, I will reduce your imprisonment by 3 months. On what basis are you equating 10, 20,000 with the imprisonment of 3 months? Is there any relation? You see the conditions of a jail. I would also hope if some of our magistrates who refuse bail also have a chance, although I know there has to be some gap between the executive prison and the jail, to see the conditions in which people who are under trial, not yet convicted, have to suffer. Are we making them convicts? Are we helping them to reform? After the lockdown, see the condition of the under trials. Mr. Malhotra knows better. There has been a prison reform committee reports. About 2/3 of people who are in the prisons are actually under trials. They have been under trials not only for very serious offense, even for lighter offense. There was a recent case last year when I think Justice Sikri, whom you mentioned, he set aside an order of conviction for murder or some high crimes after a period of 10 to 15 years. And the man was languishing behind bars for 10 to 15 years. See what happened in Arushi Talwar case. The poor doctor's reputation was finished. He could get justice, whether it's right or wrong, I don't know. But why is our judicial system taking so slow, so strong, and why do we have to reverse a convict after 10, maybe 20 years? This means that some people who may have been convicted, even by the High Court, even during appeal, they may still be innocent. The Supreme Court may set it aside after 15 years, 20 years. How do we bring this humane touch to our judicial system? That is a question. Today, rightly or wrongly, even the lawyers have become very expensive. Apart from a very big corporate house, many individuals just can't afford them. And then this is a period of lockdown. In lockdown, the access to court has become even more difficult. Many innocent people cannot approach the court. Many times it helps only the guilty people. Therefore, I am very, very grateful that Dr. Nachiketa has taken up this subject. I would also appreciate if you can invite presiding judges, along with those in the lower judiciary, to come to the same platform, and also invite some corporate houses of people who have gone through the process. Therefore, on a very fair basis, without meaning anything wrong, they can actually present their grievances before my lords themselves that, see, this is the way the system is oppressing us, or we need some improvement. You see the kind of paperwork which is involved. Mr. Malhotra is there, so I'll just tell him before him. The paperwork involved in NCLT, which is a successor of Company Law Board, which is a successor of many matters which were filed before High Court earlier, is far worse than in the High Court. As if the entire burden is only on the paperwork. Every page has to be initialed by the litigant. It is not so in Supreme Court. In every page, of course, we have not forgotten the wonderful rubber stamp. I don't understand why every page has to have a rubber stamp. What is the value of a rubber stamp today? I just don't understand. But in NCLT, unless the company puts a rubber stamp, they don't accept it. Mr. Malhotra can use his good office to get rid of the system of rubber stamp. And notary. So we all know what is the value of notary and oath commissioners. I don't need to say more. Why do affidavits have to be notarized? Why do you need an oath commissioner? And in many courts, they have the old-fashioned, you have to initial every page. Some courts, you don't have to initial every page. In many petitions, like scheme of amalgamation, if you have 5 parties, each party representative, even if it's a common signatory, he has to sign 5 times on every page. Otherwise, NCLT will not accept it. Now, what is the remedy of all this? Many courts were set up during the time of the British by charters, and they take pride on the kind of rules which were framed there. Fortunately, Bombay High Court has woken up. They no longer have this notice of motion, and I don't know what all they had. They simply have an interlocutory motion, just like the Delhi High Court. Otherwise, complying with the procedural norms, especially of the chartered high courts, and I have practiced in one from Calcutta, is a very, very burdensome task. No man can do it without the help of a lawyer. A lawyer cannot do it without the help of his court clerks. The procedure is so complex in the charter courts, and all this needs improvement. All this cannot be done in isolation, but if judges realize this problem, I'm sure they'll wake up to it. In Jodhpur High Court, sometimes I've said laughingly to retired judges, they still have a system which I've seen for the last 30 years. I went to Jodhpur High Court or Jaipur High Court 30 years ago. They have a system where you have to say that the PI and stout papers are not readily available. Therefore, I'm taking exemption to have the matter typed on a normal paper, and you have to apply for a separate application for it. 30 years down the line, today, when we filed it 3 months ago, again the same thing. Since I happen to know some retired judges, even from Supreme Court, I just jokingly asked them, they started laughing. I said, in 30 years, if you can type in normal paper without stout paper, why do you still have the same rule? Nobody has an answer. There is a certain lethargy. People know the problem. People know that this must be resolved, but there's a lethargy against resolving it. And I'm talking about only the procedural issues. The procedural issues are very, very complicated. The law system should be such. That's why I'm glad that the magistrates and the lower judges are there. The focus must be on substance. If you divide the time between the matters, between the time you spend on procedures like service of notice, checking the cost title, checking the verification, checking the signature, oath commissioner, rubber stamp, and the time when you actually spend on the substantial issue, you will be shocked that the substantive issue doesn't take more than a couple of hours. But the procedural issue can go on for months at an end. This new technology which we have learned during the lockdown period is also useful. I'm aware of the abuses. It is very easy to abuse the technology, but yes, many of the services today should be done on email, can be done on WhatsApp and other alternative modes, and the earlier modes should not be necessary, except in certain very strict cases. So I'm very glad that technology is being used, even for bail and surety. Today with provisions of GPS and other technology, why do you need bail? Why do you need surety bond? A man can have a chip with him, he can report online, he can report to the nearest police station or whatever form you think is safe. So I'm very glad, sir. I've just given my frank and candid views because a legislator, former law secretary is there. He can carry a point of view forward. And you, Nachiketa, because you're running the law school, you can exchange the views even with the sitting judges because our target is the same. We want justice. Actually, it should not be law. It should not be justice according to law. It should be law according to justice. We have to follow dharma. Thank you.
Thank you so much, sir. Thank you for the very elaborate and message, which carries a lot of pieces of advices for me, for a lot of our lawyer friends, law teachers, and as well as for the members of the judiciary. Indeed, I agree that it's about a very comprehensive, detailed, consolidated kind of an approach which is necessary for preparing a judicial officer, and the preparation should be as elaborate as possible. That's why as we have been experimenting in the virtual law school also, so similar kind of format that we will also try to follow in the Judicial Preparation Advisory Center, that beyond the regular curriculum which is necessary for judicial service aspirant to sit and qualify in the judicial service examination, beyond that we will be organizing certain small training programs, certain special lectures which could widen the horizon, which could help them in a very different way, more than merely looking at the judicial service examination as the end goal. So which probably, I believe personally, having rubbed my shoulders with a lot of my senior colleagues and friends even in the judiciary, that there are certain pieces of legislations which sometimes go missing even from the curriculum of the state judicial academies for the training purposes. So not that certainly we cannot do that kind of a job, but still in our own way, whatever little we will be able to push for. So the idea is to also enhance the capacity of these young law graduates who are aspiring to go behind the wheels and accelerate the justice delivery system tomorrow, to have that kind of abundant and adequate knowledge beyond the only procedural laws or substantive laws of one kind or the other, which help them qualify the exams. So we will definitely work on those issues as well, sir. Thank you so much. And now, my dear friends, I'm very happy to request Mr. Malhotra to share his views, given his wide experience as an Indian legal officer in the Ministry of Law and Justice. He has seen through a lot of courts, lot of legislative debates, lot of processes that go in enriching and also strengthening the judicial system, and also different kinds of laws which we all study as part of our curriculum. So I believe that Mr. Malhotra's words will also help us in a lot of ways, and sir, I look forward to a lot of suggestions that what are those kind of distinguishing ways that we can try to make a kind of a difference in preparing the judicial service aspirant, not something which is going to cut through the traditional kind of an approach that we all have been used to. Thank you.
Thank you. Thank you very much, my dear friend, Mr. Suman Jyoti Khaitan, founder and managing partner of Suman Jyoti Khaitan and Company, Mr. Amit Vashist, Regional Provident Fund Commissioner, and my good friend, Professor Nachiketa Mittal. First of all, I must thank Mr. Professor Nachiketa for giving me this opportunity to be part of this inaugural ceremony of the Judicial Preparation and Advisory Center, because I personally feel that in spite of the fact that we have large number of centers already operating in the country and preparing students for judicial services, but as you yourself said, probably they have set timing, set courses, and the kind of flexibility which law students or the young lawyers need to prepare for judicial service, probably that kind of facility is not available. Therefore, there is a need of this kind of center which you are doing, and with your vast experience as a professor of law within India and outside the Indian jurisdiction, as well as with your vast experience of working with the Supreme Court also, I think the lead which you have taken will definitely be of great help to the aspirant of judicial service. Now, talking on the topic of the day, I must say that my two previous speakers, my dear friend Mr. Suman Khaitan as well as Mr. Amit Vashist, have made my job difficult as well as they have made my job easy. They have made my job easy in the sense that whatever I wanted to say, both of them have said much more than that, and probably I can simply say that I endorse what both the previous learned speakers have said. But they have made my job difficult in the sense that what more I should add to what they have said. So in this background, I think I must say that what Mr. Khaitan has said with regard to the judicial service examination preparation and what the center is supposed to do, that center has to do something more than what the students are taught in the law college or the law university, or what in the initial years of their practice they learn in the court. Because I think judicial craftsmanship is entirely different as compared to other areas of field. You see, a very good law student, he may be a very good lawyer, but he may not necessarily be a good judge. A very good judge need not necessarily be a very good lawyer, because the skill required there is entirely different. So I think we have to take all this into account, and what Mr. Suman Khaitan has said, that extra legal studies are also equally important when you want to become a judicial officer. And for that matter, I will advise that all those who are preparing for judicial examination, in addition to their knowledge about the procedural laws, about the laws passed by the parliament, they must do some extra legal studies also. And these extra legal studies are available in the autobiographies of many distinguished lawyers, and some of them which are immediately coming to my mind, which I also studied, and I will recommend to all the students, whether he's a practicing lawyer, whether he's a judge, or he's preparing for a judicial service examination. Take, for example, Seetalwal's, MC Seetalwal's autobiography, or for that matter, Justice Khanna's autobiography, or MC Chagla's autobiography, Roses in December, and many more by Andhya Jina and others. I think all these are very good reading, and probably they made them a very wise legal person in addition to becoming a good practitioner. Now, talking about the judiciary, all of us understand, because most of the participants here are students of law or the young lawyers who are practicing law. I think all of them, if they are really interested in preparing for judicial examination, they must understand what the requirement of the judiciary is. All of us understand, so far as the higher judiciary is concerned, here when I'm talking about higher judiciary, I'm talking of the Supreme Court and the High Court. The procedure of appointment is entirely different. But now the Judicial Preparation and Advisory Center, it is basically concerned with appointment of at the level of the lower judiciary, which again can be divided into two parts, that is the magistrate and sub-judge, which is where there is a direct judicial service examination conducted either by the State Public Service Commission or the High Court of the concerned court, concerned state. And then you also have the higher judicial examination, where you make direct entry as additional judges. And I think your kind of center which you are contemplating will have to give training and advisory for these both kind of training program for the higher judicial service also, as well as for the judicial service examination. And as on today, as we know that we are a federal structure, and in this federal structure, though legislature is dual in the state as well as in the center, and the executive is also separate, but so far as our judiciary is concerned, we have a unified judiciary, and it has to interpret and administer the law passed by the state government as well as central government. So the knowledge imparted to a student to get a law degree is not enough for qualifying a judicial service examination, and a separate kind of training is required. Which, Mr. Nachiketa, the kind of job which you have undertaken, I think it's a very onerous job, and your team, whatever you are having, and the interaction which I had with you, which I understand, the kind of preparation which you are going to give, the kind of expertise which you are bringing from the professors and other things, I think that will be a good value addition for the students who will be preparing for this judicial service examination. I think I'll again go back to what Mr. Suman Khaitan has said. That is, a judicial officer, you have not to understand only the law. You have to go much beyond that. You have to understand the requirement of the society, and you have to see that the law is applied as per the requirements of the society, and without doing violence to the legal language, it is interpreted in a way that it subserves the cause, and for that, the goals which are enshrined in the Constitution become very, very important. Now, I know from my own experience, and you also mentioned about it, that I have been associated with the drafting of legislation as Secretary Legislative Department as well as Secretary in the Ministry of Law and Justice, because all laws which go to the Parliament are scrutinized first in the Ministry of Law and Justice, and only then it is introduced. And it is always said, I mean, I'm saying on the lighter side of it, if there is a deficiency in the law, it is the draftsman who is responsible for it. But if it is a good law, then it is the legislature who has passed a very good law. This is what generally said. But yes, you cannot draft a perfect legislation. Mr. Khaitan has pointed out many deficiencies. Take, for example, in the Companies Act or for other economic legislation, there are so many compliances to be done, which probably, I mean, if a businessman start looking into all those things, probably he will not be doing any business. And maybe he has to see that he is complying with all the laws, because if he is not complying even with the procedural requirement of filing a statutory return, maybe he will be put behind the bar. Now, he is more interested in doing his job than in these compliances. And probably once a matter come before a judge, a magistrate, for this kind of procedural violation, what should be his approach? Should he apply the law strictly and giving a strict interpretation, send the person to jail, or he should ensure that the law is complied with and impose a punishment, which is the discretionary power given to a judge? So I think this kind of approach is more important. And I'm reminded of the words of the framer of the founder of the Constitution, Dr. B.R. Ambedkar, when he was participating in the constitutional debate in the Parliament. He has said, no law is good or bad as the person thinks, but it depends on the person who is going to implement it. If he's implementing it in the spirit in which it has been enacted, the law will be good. But if he's not implementing in the spirit in which it was made, probably the law will be bad. So I think we have to keep, as a judicial officer, we have to keep that factor in mind. And the people preparing for judicial service examination have to look into all these aspects. Now, coming about to the constitutional provision with regard to the judicial services, let me remind you that initially, of course, there was no such concept. But by the amendment in the Constitution in 1976, this provision for All India Judicial Service was incorporated. The idea was very simple, that there should be people who are recruited to the judicial service. They should come with some experience. And here, when I'm talking of All India Judicial Service, I'm talking of the higher judicial service, that is at the district level, because the approach will be still continuing that at the judicial service, not higher judicial service, at the judicial service level, the recruitment will be done either by the State Public Service Commission or by the by the High Court of the concerned state. But so far as the higher judicial service is concerned, ADJ level, there should be an All India Judicial Service. But unfortunately, that has not still seen light of the day, because among the judiciary itself, there was no consensus, and probably most of the high courts are not on board for bringing the All India Judicial Service. As Mr. Khaitan also pointed out, probably the kind of consensus could not be built up for the simple reason, because, and I'm sorry to say again, that probably the turf or the power which any organ of the government is enjoying, they don't want to leave that power, even if it is in the best interest of the country and for reforms or maybe part of the judicial reforms. So even today, many of the high courts are not on board, and they don't want that All India Judicial Service should come. And one of the reasons which is given for this is that a judicial service must have a good command on the language for the state. Suppose a person from Delhi is selected in All India Judicial Service, and like All India services, he's given a posting in, say, Kerala, or he is given a posting, say, in Andhra Pradesh, he will not be well conversant with the local language, and therefore he will not be able to deliver justice because he will not understand the case. But I think this argument is misplaced in the sense, because even in respect of All India services, be it a forest service, be it IAS or the police service, people from other states are posted to the different states, and it is mandatory for them to have a command on the local language, and unless they qualify that examination, they are not given a posting. I think similar kind of provision can be made even in respect of All India Judicial Service also. And now at least the government is also on board, and my understanding is that a bill is under consideration for All India Judicial Service, and probably institutions like Judicial Preparation and Advisory Center can play a big role in seeing that this kind of proposal, which is now under consideration of the government, comes forward and it is implemented, because All India Judicial Service will have a better advantage that students of law, they will also be getting better opportunity to apply for All India examination and serve anywhere in the country like all other civil services or All India services are doing. So I think that's a very good proposal which has not seen light of the day for quite some time, but now at least government and even the Supreme Court is also on board. But as I said, we have a long way to go, because most of the high courts are still not accepting this proposal. But the kind of majority which now government is enjoying and kind of persuading power which it is having, maybe it will be possible to see that during this tenure of this government, probably this kind of legislation is passed, and Article 312 of the Constitution, which has been there on the statute book since 1976, at least now sees light of the day. And this will definitely give better opportunity to the students to participate in the judicial service at all India basis instead of confining them to a particular state. So with this, I think another point which was at the back of my mind, and I thought that I must share with you is, let me see, that, yeah, of course, in addition to this judicial service examination, the other point which I wanted to say today was, because we are going through a very, very difficult time. And in this difficult time, as Mr. Amit Vashist also pointed out, that every crisis brings some new opportunities in the forefront. And similarly, COVID-19 pandemic has also brought many new opportunities for us. I can share with the participants here, and I think who knows it better than Mr. Sumit Khaitan as well as Mr. Amit Vashist. There was a time when the courts, so far as implementation of information and communication technology in the courts is concerned, earlier we thought filing of the your petition or filing of the documents, pleadings, as well as uploading the judgment, uploading the your cause list on the website is implementation of the ICT. And the judiciary, as well as most of the advocates, were not willing for virtual court proceedings. I think COVID-19 has come out with that kind of a situation where no option was left. And since you have to carry out the work, therefore carrying out the work, this virtual court process, which would have taken another decade or so for implementation, has now been implemented. But yes, it has got its own problems because it has divided even the legal fraternity into two classes of haves and have-nots. I think time has come when judiciary has to ensure that at the district level and tehsil level, if it is not possible for individual to have this kind of infrastructure, at least the centers are created where people can approach, the litigant can approach, and they can use these services so that the technical divide which has come into the society can be avoided. More importantly, we have to ensure that a confidence is developed among the litigant also that participating in the virtual court is as good as participating in the physical court. And that can happen only when we bring the technological reforms which are immediately needed, the kind of technical security which is required, data protection as well as security which is required, and the confidentiality which need to be brought into the system. I think these are the areas which should be attended to by the system immediately, so that in virtual courts also we are able to instill the kind of confidence which is needed, and people can participate in the virtual court, at least in the area where physical presence is not required. I'm very sure that so far as even today also, many of the courts which are working virtually, there are difficulties, there are technical glitches, although I'm participating in seminar, webinar, and even in handling some arbitration matter also through virtual hearing. But there are technical glitches, and sometimes recording of evidence is a problem. Looking at the documents itself becomes a problem. These things are to be looked into, but a day is not far off when I know that a lot of the work can be conducted through virtual court, and it will save a lot of time even for the consuls also, that sitting, like, say, take for example Mr. Suman Khaitan sitting in the comfort of his office, he can attend a hearing in Chennai. At the same time, the next hearing he can attend in Delhi, and the third hearing he can attend in Kerala. So I think that kind of comfort is also coming. So we cannot avoid use of technology. Technology has to be used, and quite possible a time may come when you are holding your judicial service examination also, you are conducting your judicial examination also through the virtual examination. And it happens, like in the university you are doing, this can also happen. Only thing as the advice I mean, which is not relevant for your judicial preliminary and advisory center, but it's a general advice to all the participants in today's webinar. We are passing through a very, very difficult phase. But because of the time it has taken, probably people have started taking it very lightly, and the number of cases is increasing. My advice to all my friends who are participating in webinar is, please take it seriously. Whatever are the standing operating procedures, we must follow them. Whatever advisories have been issued, we must follow them. Use mask when you are going out, maintain social distance, and maintain the hygiene and the sanitization which is required. And with these words, I compliment Ms. Professor Nachiketa, you and your team, that you have taken a very good initiative for preparing the young law graduates and as the practicing advocate for judicial service examination. I think it's a very good value addition. My only thing is, don't confine yourself only to preparing the students for judicial service examination. We have to go much beyond that. And even from the practicing lawyer, the kind of practical training which is required for them to become a good advocate, a good professional, I think your attention should be towards that also. Because nowadays we find many of the professionals, they are looking for easy money, and the kind of efforts or the energy which is required, or the kind of efforts which should they do in preparing their case for so that full justice is done to the client, that kind of efforts most of the people are not doing. I think they need to be told how they should conduct professionally, what are the professional ethics which they are supposed to follow. And I think your center can take up that assignment also. With that, I wish you all the best, and I'll be very happy to associate myself also as and when required, and interact with other participants also. And my advice to you is, please take benefit of the services of senior lawyers, some of the sitting judges, as Mr. Khaitan has also suggested, those who are already working in the judiciary, what difficulties they are facing, what kind of job they are supposed to do, and what ultimately is their expectation expectation of the society from them. I think all these must be told so that the person, when he goes and sit on the bench, he is not only well aware about the law, he is well aware about the requirement of the society and what exactly justice means. It is not only administering the law, as Mr. Suman Khaitan has said, and rightly so. And thank you very much for inviting me. And I'm happy to be a part of this particular function. Thank you very much. And with that, I wish you all the best.
Thank you so much, sir. Thank you for your kind words. And I do agree there's so many takeaways, so many suggestions for the Judicial Preparation Advisory Center and for myself, that it has to go beyond only preparing the candidates to sit for the judicial service examination and crack through the examination process and then, get commissioned as the judicial officers. And that's definitely one of the agendas that's going to stay with us, that it's not just about another kind of an institute to prepare the students, but we're also looking at it in terms of its long-term process, that how we can contribute, maybe collaborating with the state judicial academies in some way, which may not be an easy thing, as I know there could be a lot of procedural compliances involved therein, or probably, as you have mentioned, that how we can try to bring some of the retired judges on board, because that seems to be a plausible kind of situation which will not be in conflict with the justice delivery system in any way, which will also not be in conflict with the administration of justice, and we being the private entity will not find in anywhere closer to a disagreement with the people who are already commissioned and serving as the judges. And that's something which we already started reaching out to some of the retired judges who have also been supporting us, blessing us in the virtual law school. Some of the senior lawyers, who have been teaching also, for example, courses on criminal law. So we're trying to reach out to them. If there are some of the judges who probably cannot directly participate, but they can, help us strategize in some way, and then we can evolve a kind of training program where we can see that some of the candidates who have cleared the exams but are yet to get enrolled or get commissioned as the judicial officers. So provided before that, there could be one gestation period, so which we can utilize for ourselves to bring in that kind of a training for these kinds of young graduates before they get formally inducted on the side of the state judicial academies. And then they definitely have their own comprehensive package of training programs that they have to undergo before they're sent over to different places for serving as the judicial magistrates. So definitely, sir, that's one of the areas that we're going to look forward to. And the another piece of advice that you mentioned, that how the technology can be used, I do agree. When the courts have gone virtual, so I've been thinking ever since as the law teacher, so we can also meaningfully impart legal education and law classes in different ways. And as I have been talking to a lot of young friends, so their viewpoint has been that when they are in bigger cities, the travel time is quite a lot. Somebody who is a serious aspirant for the judicial service, so somebody, for example, I have stayed in Delhi, somebody who has to travel from all the way from South Delhi to North Delhi, where most of the judicial service preparation centers are located in Mukherjee Nagar. So it involves like around 3.5 to 4 hours of our traveling time. And then you are lost, in terms of your mental and physical fatigue. And then you also sit throughout the day for the preparation of the classes. So what is the time that you're going to save for yourself in terms of your, mental relaxation? Then, reuse the techniques that you've learned to prepare yourself. So probably the technology is going to do that kind of, wonders in terms of benefiting a lot of young aspirants to cut through that kind of a traveling time, but still get the same kind of quality which can help them prepare through as it would have taken place in the normal circumstances of the physical setting. But since we have done away with that physical setting under the compelling circumstances, I believe that through the Judicial Preparation Advisory Center, through the online classes, we can bring all of those, back in the houses and in the study rooms of our students. And for what we are doing, sir, some of our colleagues who are supporting in this movement, we are ordering for them some of the equipments which can help these law teachers teach very effectively. For example, that we cannot have the regular whiteboards or the blackboards. in these times, unless we are going to, put up the our phones or the laptops at such height, and we can use the whiteboard in the background. So we are trying to invest in technology where the writing boards, which are the soft boards these days, we are procuring them, and those will be used by our teachers to use, and several other equipments for the purpose of teaching, where we are investing firstly in the teachers, and then we can roll out a long-term plan for the for sharing up some of these kinds of tools with the students also, which could be part of the entire package. So, and then at the end, as all my dear friends here know, that we have kept the demonstration classes also today at 7 o'clock, and also tomorrow at 6:15, and there'll be few more coming up. So please attend to them, and if you find it feasible, we welcome you on board in this journey where you can pick up and take up the branch-wise selection of different kind of courses without any kind of foundation that you have to go for a comprehensive package, because it's, once again, re-emphasizing a thought, it's a law teachers driven process. It's not a process which has come up out of any kind of a commercial venture, but it's law teachers who are now going to run this kind of preparation, whom you saw all these years preparing the law students to go and find their own kind of choices of professions and different kinds of opportunities in the legal sector. So it's the law teachers whom you will see in a very different mode altogether, now committedly teaching also for judicial services. Thank you, my dear friends, for joining us today. I really thank Mr. P.K. Malhotra, Mr. Suman, Jyoti, Khaitan, and Mr. Amit Vashist for joining me in this program and sharing their thoughts, and also inspiring a lot of our young friends here that who are looking at judicial service preparations for the times to come. And probably, as Mr. Malhotra was saying, the time is not far, given the COVID times only getting prolonged and extended here and after further. So you may see even the judicial service examinations going online, as it is, when there are several examinations. For example, if I could just mention before we wind up, that JEE mains or NEET exam, which are being conducted for thousands and thousands of students. So I believe that there cannot be any kind of, shying away from the fact that the candidates who apply for judicial services can also undergo a similar kind of process. Only thing necessary is, which the government has all the kinds of, infrastructural things at their disposal, so they can come up with a very vibrant and robust kind of technology and technology-based infrastructure for the examinations as well. So I hope that will provide a further ease to all our judicial service aspirants to take it forward. Thank you, my dear friends, and all the best to everyone in these COVID times. As Mr. Malhotra was saying, stay safe, take care of yourselves, because especially if you are in the bigger cities and really affected, then it's a tougher call. And I hope that all of you are going to take care of yourself. Thank you, sir. Thank you once again, everyone.
Thank you. Thank you.
Thank you.